My name is Nicole Sloan. I am an attorney in northwestern Pennsylvania, and I have been appointed as PCRA Counsel in 3 different counties, and I have performed my responsibility as PCRA Counsel in numerous cases. Recently, I had the opportunity to review documents filed by PCRA Counsel in a couple different cases that made it clear that some sort of training tool was necessary. And so I'm trying to provide this as a courtesy to newer attorneys that may have found themselves appointed PCRA Counsel and that may not be clear as to what the responsibilities are. This video is not designed to assist individuals who are trying to proceed and argue issues in a case for themselves that are not attorneys. And certainly my recommendations may be disagreed with by other attorneys, but I've done numerous, I've been PCRA Counsel in numerous cases. It's my favorite thing to do, and I'm hoping that this video assists you in performing your responsibilities when appointed PCRA Counsel. And of course, PCRA is the abbreviation for the Post-Conviction Relief Act. When a judgment of sentence in a criminal case in Pennsylvania is final, then individuals that are serving a sentence can file what's called a pro se by themselves. They can file a pro se PCRA petition. If they're incarcerated in a state prison, their counselors or the law library usually has a copy of the petition. It's filed with the clerk of courts in the county where their sentence was imposed. Assuming that it's the first PCRA or the first PCRA after reinstatement of appellate rights, the sentencing judge usually appoints PCRA Counsel. Well, they're supposed to appoint PCRA Counsel, let me just say that. And oftentimes, if they fail to do that, they get reversed by the appellate courts. So even if it appears on the face of the petition that it's untimely, there may be an exception to that rule. So they need to appoint that PCRA Counsel for that first PCRA. So there you are. You've been appointed PCRA Counsel by a court of common pleas. How exciting. Well, I think it's exciting. So what's the first thing you need to do? Well, the first thing you need to do, I recommend, is reach out to your client and tell them, I am now your attorney for collateral review. And I do that by filing, or excuse me, I don't file it. I send them a letter. I write them a letter. And in the letter, on my letterhead, in the letter I say, I was appointed to represent you in your pending post-conviction matter. By order dated, whatever the date was of the court's order, whatever judge ordered me to supplement or amend your pro se petition. I tell them that while I'm examining the official records, I also need the client to write to me in as much detail as possible concerning any ways in which the attorney's performance was considered deficient by them and any communications between my client, my new PCRA client, and his original attorney, which he believes will show that that attorney did not follow their instructions, or lawful instructions, like to file a post-sentence motion, to file an appeal, a recommendation for character witnesses. I also inform them that I will ask for the record to be transcribed if it hasn't already been. If there's already been an appeal, the record is usually already transcribed. But the transcripts, if they're not already done, may take as long as 30 days, or sometimes even more, depending what county you're in. But after those transcripts are completed and I review the records and I review everything that was filed with the clerk of courts in this case, and sometimes I have to review the appellate court decision, then I'll enter one of 2 documents with the court. First, I'll either supplement the petition with my own claims or my support for my client's claims, or I'll file a no merit letter. After I review everything that my client claimed in the pro se petition, I review it for merit and everything else, whether the sentence was illegal. I just look at everything. And if I'm constrained to file a no merit letter, that's what I do. I also inform my client that I will send him copies of all documents that I file in the case. And I ask him to please keep me posted should his address or phone number change. Sometimes their state prison location changes, sometimes they're released on probation or parole, and I need to know that because I need to be able to communicate with them. So, what do I do next? I calendar any deadlines that I have. Usually in the order appointing me as PCRA counsel, there's an order, hey, you have to have your supplemental petition or your no merit letter in by a certain date. So I calendar that to make sure that I'm timely. That doesn't mean that date has to stay there. I've asked for extensions of that date if I can't get the transcripts in time. But at least you want to make sure that you know when the deadline is. The very next thing I do is I immediately file an entry of appearance if I need to, an application for transcripts. So if it's a public defender's office you're working for and the chief public defender or the office itself was appointed as PCRA counsel, then my boss assigns it to me. I want to specifically enter an appearance in the case because I don't want any documents going to my boss who happens to be a female, so I'm going to refer to her as her, because I need to see them. So I enter an appearance and I apply for transcripts. And if I do it a little bit different, because if I see on the docket the transcripts have already been filed, for example, if there was an appeal if there was a direct appeal after the judgment of sentence, then all I have to do is get copies. And I ask the court to order the court stenographers to make copies for me. If not, I have to ask for the transcripts to be filed. And so I provide a sample, a suggested order in my entry of appearance and application for transcripts, and I ask the court to order the court reporters or order the court stenographers to provide me a copy of all the transcripts if they've already been transcribed, or to transcribe the record and provide me with either a CD or a paper copy of the transcripts. So that's what I do there. The next thing I do is I run a docket, and it depends on if you have a secretarial staff or a runner, or whether you're going to have to do this yourself. But I run a copy of the docket and I look at any documents that have been filed. I want to take a look at them. I want to see what counsel did. I want to know everything that happened in this case, because that's important. So what I do is I make copies of all those documents at the clerk of court's office, and then I put my file aside for a while until the transcripts come in and I hear back from my client. Now, the only time that I don't put it aside is if the client specifically complains that what his attorney was instructed to file a post-sentence motion or a notice of appeal, and that attorney failed to do that. I have one just like that right now, and it's funny because I noticed in the clerk of court's office and on the docket, my client actually docketed his request for the appeal, and it was, considering the mailbox rule, it would have been timely, and the attorney never filed the appeal for him. So depending on your relationship with the district attorney's office in the county where you're appointed, I would suggest that you consider contacting the district attorney's office and asking if they would concede to reinstatement of appellate rights, because if they do, that's where you can stop all the rest of the stuff you're doing. Because unless you take a look at it, and if it's obvious, or if your client has additional claims that, hey, he might be more successful on a PCRA, and I don't think any claim on appeal is probably going to work out for him, you might want to communicate that with your client. Because if you have the appellate rights reinstated and or the post-sentence motion rights, depending on whether or not that attorney preserved any of the appellate issues by raising them first with the trial court, you may want to discuss it with your client. Because if it's an issue that's more properly raised in a PCRA, then perhaps abandoning that direct appeal might be a good idea, because it's taking in Pennsylvania about a year for an appeal to be resolved. And I'll give you an example of this. If I see that the court has failed to give sentencing credit where sentencing credit was due, failed to merge sentences for different crimes that should have merged, failed to give a RRI mandatory sentence, all of those implicate the legality of the sentence, and I can resolve that in a PCRA with the trial court, and I don't need to do it on appeal, so you'll waste the time up there. So you have to think about that. But if it's important to your client that his appellate rights and or post-sentence motion rights first are reinstated, then call that DA. And just Friday, Roger Bauer from the District Attorney's Office of Erie County, who's a very reasonable individual, agreed to reinstatement in my case. So I am going to be filing a motion with the trial court judge, informing him that the Commonwealth has agreed to reinstatement of the appellate rights, and hopefully appellate rights will be reinstated, and then we'll just move forward with the appeal. Now my client, in that case, will have the opportunity to file a PCRA, another PCRA, after the appeal is over. And because the first PCRA, if it's merely for reinstatement of appellate rights, doesn't count as a first PCRA. He gets another bite of the apple. So, that aside, what do we do next? Transcripts are coming in, you read the transcripts. This takes hours. If you do it right. You do read the transcripts, you talk to anyone who your client says should have been called as a witness that wasn't. And what I should have mentioned to you before that I didn't is you need to read the act, the Post-Conviction Relief Act. You look at it, there's provisions in the Pennsylvania Code, Rules of Criminal Procedure, as well as the statutes, but you need to look it over. And there's specifics, especially if you end up filing a supplemental petition. Pennsylvania Rules of Criminal Procedure 902. Take a good look. That's one thing that obviously PCRA Counsel, that I just reviewed the documents, his documents, obviously he did not do that because it failed to conform to any of the requirements. Pick up the rules and take a look at those, and you'll see what's cognizable under the act and what's not. What requirements have to be met. They're pretty straightforward. Further, if you don't already have a mentor in the county where you practice and where you were appointed, try to get one. Or I love Pennsylvania Association of Criminal Defense Attorneys, worth every penny. I think I spend $100 a year, worth every penny. The Pactal listserv, the listserv that they have is just amazing. A lot of us are on there. We want to help new attorneys, and so consider joining. So after I review everything, I talk to who I need to, I read the transcripts, I review the documents that were filed, I hear back from my client. I'm going to file one of two things. That's going to be either a supplemental petition for post-conviction relief. And again, I follow 902 and the other rules and legal authority. And I sometimes I ask that relief be granted without a hearing if it's necessary or if it's possible, but sometimes a hearing has to be granted. So that's what I do. The other alternative is to file a no merit letter, and that's in letter form, and you go through everything. And I start out by discussing, and I put it as a heading, whether petitioner's claim is timely, because it has to be timely for the court to have jurisdiction. And you'll hear clients tell you, but it's a legality of sentence issue, so it's never waived. No, it's not waived, but whether it's timely and whether the court has jurisdiction is two completely different issues. So you have to look at that. And I quote in here, 42 Pennsylvania Consolidated Statutes 9545 that specifically talk about the jurisdiction and proceedings, time for filing a timely petition under the Act. Second issue is whether petitioner's claim is cognizable under the Act. And there's multiple subsections, legality of the sentence, ineffective assistance of counsel, which is probably the number one issue. There's several of them. And go through them. Whether petitioner's claim has been waived or previously litigated. Because if the Superior Court already said on direct appeal, no, this issue has no merit, you can't now complain about the same issue on collateral review. It's already been previously litigated. Whether petitioner's claim has merit, and we go through that. And then I've been adding a new one. Whether petitioner has any additional potential claims under the Act. So in my no merit letter, if I anticipate that at some point, hey, this is an iffy issue here, and perhaps counsel should have acted a different way, or perhaps there may be an issue with sentencing merger here. I anticipate that, and I try to look for everything, which is why it's really important to keep up with case law, with decisional law. And I anticipate that, and I talk about that in here, and why even though I initially thought it might be a good claim, I abandoned that ultimately and found it really wasn't. And then you talk about how you've attached a copy of what's called the Friend Statement provided to petitioner, and that's based on Commonwealth versus Friend. It's attached as an exhibit. You write them a letter indicating, hey, I'm sorry, your claim there was no meritorious claims in here, and I'm sorry about that, and this is what I've done to review, and these are your options. And it's important that you attach that and also send that separately to your client. And of course, you're going to file this no merit letter with that attachment and many other attachments. You're going to file that, and then you're going to send both that, the original letter, and a copy of your petition for leave to withdraw, which you've also filed with the clerk of courts, saying, hey, I was appointed, I've determined that the defendant has failed to state a colorable claim for relief under the PCRA, and I'm constrained to ask to withdraw. So, and that's what you do. And I hope this has provided some assistance of PCRA Counsel. I really enjoy working with PCRAs. I hope you do as well, and I wish you the best of luck.